If that's okay. Perfect. Thank you very much and welcome everyone to this third Let's Talk About Legal Design online series. Today we have Dr. Clement Guitton here from the University of St-Gallen. He's a postdoctoral researcher at the School of Computer Science here at the University of St-Gallen. Clement has a very interesting background because he combines this computer science element and political science and has been working more and more also within the legal field, notably also with me as a co-author. And so I'm very excited, Clement, that you're here today and that you present us these results of this vignette study on social acceptability of legal automation, or how it's called, and we call it automatically processable regulation, so APR for short. So thank you very much for being here, and the floor is yours.
Thanks for having me. Yeah, my pleasure. So I'm going to present the results of a study we have conducted last year, and which is currently under review. And so the study looked at preferences behind legal automation, and let's start why it matters. So not sure to which extent some of you will have already seen that, but we've had a couple of scandals around legal automation. So legal automation in the sense of governments using computational methods to try to fast track decisions, be it on who should receive social benefits or who should be investigated for potentially being a fraud against social benefits. And so here you have on the slide a prominent example of what we've had in the Netherlands. So where such a system was being used, and then it was flagged very early actually by the parliament as being problematic, as using data to pinpoint at people as being potentially fraudulent, as defrauding the social system, but it was targeting them specifically because of their background, so of their migration background. When this was pointed out, then it was first ignored by the government, and then a big scandal exploded once it became clear that the government had been aware of this. And critically, I think, is that the impact of such decisions were really impactful for people. People suffered extreme mental duress, extreme financial duress, as they were accused of having defrauded the system and being asked to repay tens of thousands of euros. And this was actually wrong. The decisions were wrong, the decisions to target them were wrong, and so on. And so this is not an isolated case, and I guess that's a bit of the issue, is that here you have another example in France where a similar algorithm, or the algorithms may be very different, but the goal of the algorithm is very similar, is to try to identify who is defrauding the social benefit system, and you have that in various parts of the world. I'm not going to list them all, but you're starting to get the gist here, that we have these algorithms that have been deployed by governments and that are causing problems. So now we put that under legal automation because it's not only for the application of social benefits. So under legal automation, you have a host of different possible applications that help to either make the law more efficient or that help people interacting with systems to know whether they have certain rights to apply to benefit, whether they have certain rights for certain tax rebates, or in general, whether they have certain rights to do something or what they could be doing in a dispute with someone. So this is what falls for us under legal automation. But so out of these scandals, what we can see is that, okay, there are a lot of them. Really, you'll find some in India and in really other part of the world. But what comes out of it is that there has been very little public consultation on whether the public wants them at all. So you'll find certain studies on post hoc, after the implementations, right? Did really people want them, or are people aware that their governments have been investing money in developing and using these systems? And then out of these scandals, there is also something that comes out of it, is that there's clearly a mismatch between how this system has been deployed, specifically with biases and so on, and the lack of transparency on how they've been coded, how they've been trained, and then what the public could have expected out of these systems. Not only in terms of could have expected in terms of outcomes, but in terms of as well defending their own interest if something goes wrong. So in terms of contesting their own case, but in terms of contesting as well potentially how the algorithm has been developed, deployed, trained, and so on. So all the different steps behind the algorithm. So where we came from is then to say legal automation inherently is not bad. So sorry for the acronym. So that's APR, that's for automatically processable regulation. What made it bad in this scandal, if you want, what led to very negative outcomes was because of specific choices that were made during implementation. Choices such as not making public the codes, not subjecting it to a specific review, not setting up contestation mechanism, and in the case of the Netherlands, even more problematically, not reacting to early reports that the algorithm had issues and was discriminately targeting a certain subgroup of the population. So with this in mind, that these implementation choices then have an impact in how legal automation can be deployed and can be deployed in a way that is more responsible, then we sought to investigate what are preferences around implementation. So here are a couple of hypotheses that we took. So the first one, I guess, is sort of maybe the more intuitive one. So would people prefer that a judge uses legal automation, or would they prefer that a member of parliament does so, or a public administrative, someone working in a public administration capacity, a public administration clerk, so say for the administration of social benefits or something else? Then the aim. So I talked about how some of these are now to make the law more efficient, so that you speed up you fast track the application of certain processes, or to try to support then someone's interpretation of the law, be it an institution or different parties, different lawyers' interpretation of the law. Then another hypothesis that we had was, would there be a preference for legal automation in specific legal fields? There are, if you take criminal law, it's sort of, it goes without saying that the sentences that are associated with criminal law can be a lot more consequential than what you can have within social benefits, for instance, being just denied or you would receive social benefits, whereas in criminal law, potentially if the judge applies criminal law automatically, then the adverse effects could be a lot more problematic. Huh? The next one is the data provenance. So is the decision based on data submitted to the institution only? Is the decision based on all data someone would have given to public administrations in general, or to even all public data that is available? So if a person has posted on Facebook, on Twitter, and whatnot, then a legal automation tool would also be looking at this data. Who triggers the process? So these ones matter specifically because there is now this idea of proactive administration. It's an idea that originated rather on the left-wing part of the political spectrum, of saying certain people have rights and they should not be applying for these rights because they are there by law. So the state should be already proactively taking steps to make sure that the people can take up their rights. And so the idea is that people don't need them to apply, say, to social benefits or to a specific tax rebate, because they have the right for it anyway. But that then the state proactively give it to them, provide it to them. So we've investigated that, and you'll see in a minute, we've actually divided a bit our study into aspects so that we target a bit more this proactive administration discussion, which is something very much ongoing, specifically in France. H6, the level of automation for data entry. So do you have to enter everything manually? Do you only check what's already pre-populated and you only have to validate? Or is everything automatic? You don't see anything and then everything goes through. And the two last hypotheses, so age hypothesis was specifically in one direction. We would have expected older people to be more reluctant in the use of automation. But I think in the paper we left it with that direction, but we had sort of specific expectations. And then for the last one, we asked people as well to give us the reason why did they accept a system? What's behind then the score that they're giving for them accepting a system or not? So different reasons, and one of the reasons was trust and distrusting the system, and so we hypothesized that this would already be the most common reason. I'll show you a bit more in detail in a minute. So from these hypotheses, so we crafted vignettes. And so vignettes are short text, and you have an example of the short text below. So the usual vignette study is a 2x2 design. So you have two variables, and each variable can take two values. So you get 4 vignettes. Now, as you've seen, we have a lot of hypotheses, and each of these hypotheses can have quite a few values. So instead of only 4 vignettes, it led us to basically 432 vignettes in one case, in the general case, with the values that I just showed you here, judge, MP, public administration, and so on. And then we conducted in parallel another vignette. We called it the narrow case, where we only focused on the proactive administration case. And that is because it's a discussion that is not only theoretical, but where there are currently concrete discussions in France to proceed with proactive administration. And in this case, what happened, and that's why there are less combinations, is that we fixed a couple of the values. So, for instance, in terms of aim, we are clearly within an efficiency goal. So we're not testing the accessibility one. The public who triggers it is then is the institution. So that's the whole idea behind proactive administration and so on. So we have, sorry for that. So we have less variables, and then something we were interested in was, are we going to see some differences as well between general and narrow? So we put out these different vignettes to participants, and they would not be aware that basically there are other participants that are being shown other text, and that this text is being tweaked slightly each time. And we all asked the same question. The exact phrasing of the question I don't remember, but it was something along the line of, how much do you support such a scenario? And then they have a scale from -5 to +5. And so it helps us then when we take different averages across the different variables, and when we look at linear regressions across then the scenarios, you'll see that in a minute, it helps us to see whether there are specific preferences for specific scenarios, and in general, what's the overall acceptance. So that was for the methods. So as mentioned, we had close to more than 500 vignettes. So we then asked a lot of participants. So here you have the numbers for how many vignettes assessments then were made. So in average, what you can see is that each vignette was assessed 12 times. So yes, it's not so much, but it doesn't, there is obviously a big overlap with factors. Huh? So a factor will come up in a lot more different vignettes. So which allows for still using statistical tools that are relevant. Huh? So it's just to show you sort of per vignette, per the number of vignettes, that's what you showed below, how many times each were assessed. Huh? So going to the results, what did we see, what matters, and what did we find that did not matter or mattered less? So the first thing that we did was linear regression, where we just dumped sort of all the value together for the general case and for the narrow case, and then we saw which variables here had a specific role, could drive then social acceptability. So we saw that institution does, aims does, data provenance, and automation level. So it's a bit, in the general case, it's a bit disappointing in a sense that then legal field, we were expecting legal field to also play a role, but we could not conclude on that. But then for process trigger, it's also interesting that in the general case, we did not have a difference, whereas in the narrow case, we did have one. So the interesting bit is that once we know that there are differences within a specific group, and then can we try to work out which group is more or got more support in using legal automation? And so not only for which institution, but as well for each of these hypotheses, each of these variables. So for the institution one, the interesting one, or one of the interesting conclusions, is that public administrations, one second. Yes. So to read this is that the pair on the left is always less than the pair on the right. So the score for pair 2 is always higher than the score of pair 1. So members of parliament have a higher score of being accepted. Sorry, it's the other way around. The pair 1 has a higher score than the pair 2. So it's always classified like this. So judge has a higher score than members of parliament. So members of parliament have the lowest acceptance of the three institutions. Now, this comes at a bit surprising for us, because members of parliament, they may use tools for legal information, for instance, to summarize documents, to summarize amendments to legislation that is being done. So it's less on a case-by-case basis. Individuals are less impacted by it. So one of our conclusions here is to say that there is this confounding effect where people may not have the best acceptance of MPs. And so when you ask them about acceptance of a general scenario, when MPs are involved in it, they just dislike it. So there is this confounding aspect of basically not about the scenario and the legal automation within this setting, but it's also about the institution per se. So in other words, people prefer judges to MPs. Well, it's sort of, I guess that flows from the assumption that yes, politicians are not always necessarily well liked. So another one that we see that we can conclude from that is on the legal field. So the p-value here, you can see that for certain legal fields, we're not able to draw a conclusion. So we can't say, for instance, that there's a preference for tax field above social benefits field. So the two are too close to each other to be able to make a point there. But we can say that it is, in comparison, that tax law, people prefer legal automation concerning tax law than they do concerning, if you compare it against nationality law or if you compare it against criminal law. And the same, there is a preference for legal automation concerning social benefit laws when compared against nationality or criminal law. And then the three last ones are interesting in the sense that the least automation is always the preferred case. So when you're the one triggering the process, is preferred than when an institution does it. And when public data, so data only in the public administration domain is processed, is, well, that's almost obvious, but it's preferred than if all public data is being used. And on the automation level per se, it's similar. People prefer when they do everything manually rather than if they have to validate or everything is done completely automatically. For the narrow case, we see these points on automation again. So this comes back. Major difference here will be on which data provenance point has got the highest preference. And in the case of the general case, data provenance was on all public administration data, whereas here we have on institutions. So I'm coming specifically from the institution within the scenario. And we come to how people then resonate, how people then justified their rating against specific scenarios. And this matched our hypothesis that most of them thought that they disliked or trusted, sorry, so in terms of trust and distrust, the institution using legal automation. I think I said something wrong at the beginning of the discussion. So it's not about trust and distrust of the technology, it's trust or distrust of the institution. We try to look for a connection between these reasons and age, especially because in the narrow case, it was extremely close to being statistically significant at the 95% confidence interval. I think the p-value was at 0.06, but we could not really find anything that was that matched. And so here, just looking at, you see here a breakdown of average acceptance, so the score given by groups. And so you see there is a spike in groups of people aged 70 to 80. We consider this an anomaly. So we're using Prolific, which is supposed to have a good data set of real participants. So we filtered on people based in France and who spoke French. And we're not really sure how to explain this. Either people do not really give their real age, or it turns out that we have a sort of a bias with elderly people in our data set. But it's also interesting, so that we have this spike. So it sort of decreases. So you have a higher acceptance when people are younger, but all of a sudden you have a spike with a group of 70 to 80 people who claim we have 70 to 80 people who all of a sudden show more acceptance for the scenarios and for legal automation. Now, what you may have already noted is that these averages on the left are fairly low. So as mentioned, we ask people between -5, so -5 you'd be rejecting the system, and +5 you'd be very much willing to have a scenario in which such systems are being used. But in general, then we see very low acceptance for legal automation across all of our scenarios. And I think this is telling when you compare that to the scandals I mentioned at the beginning, that basically there is already low acceptance for it. So anything that is not very well managed is then going to be basically a flame or sort of something that triggers a fire. And on top of that, yes, in the scandal that we've seen is that there were really quite a few issues with the implementation. The percentage of people which did not understand the vignettes was, I would say it's fairly low. So we had 13 people that clicked, 13% of people who say they did not understand the vignettes. Now, for me, it was expecting that we have a certain percentage of people. It's a very niche topic, legal automation, and yes, certain the whole thing we're describing within 5 lines with a vignette study is sort of closer to a gut feeling. And so you're asking people to picture a scene within 5 lines without giving them really proper background. So it is to expect that certain people will not get what you're trying to describe. And so for me, 13% of participants not getting it is still within sort of expectations. But so from the takeaway, specifically from a legal design perspective, well, what we took away from that is that, yes, people want to feel in control of the process. So with legal automations, that's the point, specifically about them triggering the process, them still giving the data, specifying which data they want to give, and so on. And obviously here we analyzed already 500 combinations, 500 plus combinations. So we could not analyze all aspects of legal automation that gets to be implemented. But there are other choices that are independent of the specific implementation of legal implementations. So two are mentioned here. So proper training of civil servants. So, and then trying as sort of a trust or a confidence measure, confidence building measure as well to the public of civil servants then being able to correctly use what is being put at their disposal. And then the second one is participatory design, would be to say we involve people very early and at different stages of legal automations. So you make it transparent, but at the same time, you allow people to express their preferences on how the process is and the tools are going to be shaped. And then they get as well then this feeling of being heard and of, especially if their point of view is then being implemented, what we argue should be the case. Huh? Yes, and that was the end of it. So happy to discuss.
Great, thank you so much, Clement. I think we can stop the recording now and open to a Q&A. You can also stop sharing your screen, and everyone who has a question can put it, of course, in the chat or just raise your hand and unlock